Episode 9, The First Hurdle, Executing Service in a Georgia Family Law Case. Welcome to the Stephanie Young Law Podcast, hosted by me, Stephanie Young. I'm a family law litigation attorney in Covington, Georgia, with a passion for being my client's biggest legal ally. If you find this content relevant and you want to hear more, I ask that you subscribe, share, and interact by liking and commenting down below. So in today's episode, I'm going to discuss the very first hurdle that you face in initiating a family law case in Georgia, which is service. I say first hurdle. I can't promise the only hurdle, okay? It's case dependent. I can't promise. But I will say it is the very first hurdle. Before you file the case, you honestly need to think about the type of service that is better suited for your particular case. This is very case specific. So the first thing, what is service? Because hey, that's fine. The purpose of this podcast is to try to educate you. This is not legal advice, but just generic. These are some facts about litigating family law cases in Georgia. So what is service? It's okay if you don't know. It is the legal process of serving a lawsuit or a summons. So service is necessary in every single case in order to formally proceed. So what does that mean? It means that you can't just keep the case moving and not have executed service. You might hear that word, executed service. The judge will say, well, has service been executed? If you don't have another party show up. And we can talk a little bit more about what that looks like as you keep following along. So except for ex parte matters. So in the law, and if you've listened to some other episodes, you probably realize that the law in the legal field uses a lot of Latin terms. So what does ex parte mean? Ex parte means without a hearing. And so basically what that means is unless it's an ex parte matter, which is a very particular subset and not a very common thing to get an ex parte order, is every single initial lawsuit and summons must be served on all opposing parties before you can appear before the court. So why is that? Okay, it goes back to our constitutional rights in the United States. Due process. You have the right to be able to be notified and heard before your rights are taken from you, right? And when I'm talking about rights, I'm talking about life, liberty, property. If you think about family law cases, you think about your kids, right? That's huge. The custody of your children and even just visitation of your children is a huge part of your life. If we're talking about divorces, we're talking about your actual house and your property. And if in other cases like contempt issues, you could be facing contempt going against court orders. You could be facing confinement on child support arrears. If those things are alleged against you, you could face confinement, your freedom, your liberty. So again, it's just very, very important that due process is followed, and service is a huge part of how family law cases are checking that box, okay? So we're gonna go over the types of service in Georgia. I say Georgia just because this is where I practice. If you've watched other episodes, you know that all of my topics are going to be centered on Georgia, the Georgia law, not any other state, not because there might not be the same, or maybe they could be, but I am just specifically telling you that you would have to seek an attorney that is barred in that state before feeling confident in knowing that translates from Georgia to that state. So we've got sheriff's service of process. And again, we're gonna break these down, but I just wanna give you an overview. Sheriff's service of process. Then we have a process server. I know that those kind of sound similar, but we got the sheriff and a process server. We have an acknowledgement of service, and the other option is service by publication. Okay, so those are the 4 types. And when we're done with this episode, what I will promise you is you will be able to understand what all those mean, okay? So we'll start with the default. I'll call it the default method, sheriff service of process. So whenever you file a lawsuit, all family law cases now in Georgia do actually have to be e-filed. So that means that even if you're a pro se, which is you represent yourself and you want to file for a divorce or a custody modification, you file online. You can create an online account and file online. Depends on the county as to which e-filing system. You would think that we would have a generic platform, right? Yeah, that's like a lawyer thing where you could probably ask any family law attorney and we're going to be like, yeah, we should be all on the same page. We should get Peach Court, not Odyssey. Anyway, that's just an inside joke. If you know the differences or are a paralegal or know anything about e-filing, Peach Court is superior. But anyway, it does depend on what county you're using. But if you go on there and you file your lawsuit, so whatever that may be, like I said, it could be a divorce, it could be a custody modification, it could be a contempt action, it could be about child support, it could be a legitimation, whatever falls under family law and civil, and you're going on there and e-filing it, there's going to be a box where you have to answer and say, how do you expect this to be served? So automatically, as I said in what I just said a moment ago, is that it's going to be up to you you need to be pre-planning this. This is something that you should make a decision on before even filing your case, because you're going to have to answer when you go to file, okay, which option am I choosing? So I say the default method is service by the sheriff. And that's what you hear about, right? Like a sheriff came and served. If you see on TV or tacking on the door, that sort of thing. Again, we can talk, I'll tell you how tacking something on a door is not proper service for family law. Anyway, so we'll talk about the pros and the cons to each method of service because, again, and not all methods are available in every case. So it's $50 basically across Georgia for the sheriff to serve. So that's a pro. I say that's a pro. $50 to have your case served. And again, that's not filing fees. That's not going to the court. That is literally going to the sheriff's department. Is very affordable. It doesn't require any kind of motion. It doesn't require anything further from the court in order to proceed. So what that means is if you go on and you e-file and you click I'm going to have the sheriff coordinate service. You pay the $50, you can kind of lump it up with your e-filing fee. And then the papers, you can also, even it's easy as you can get the clerk to send the stamp filed whole packet to the sheriff for you, which is fantastic. So you don't even have to contact the sheriff. They get it from the clerk, they get your money from the clerk when you file, and they go ahead and do the service for you. And then you'll just get a nice form back that says service has been executed. So that's great. It's easy in that way. Those are all I'm making it sound really great, don't I? The cons are coming. So yeah, I mean, and it is a very respected method by the court. The reason I say that is because the sheriff is just the default method. If the sheriff has said that they have properly served the summons, the service packet, then the court is going to respect that. And you know, it's I'm not saying it's completely you can't irrefutable, but I do think that the court very much as the default that it's respected and very, very infrequently disputed. Let's talk about the cons, okay? You have no control on timing, right? So when I said what I just said is like you send it to the sheriff, whether that's through the clerk or if you cut a check old school and mail it, to the sheriff's department for them to serve, that they then get it, right? And you have no control over their schedule. That could sit depending on how sometimes like there might only be one deputy in the whole county to execute service. And so you could be on a backlog. You don't know the backlog either. Like you have no idea. So they could be on a backlog where you might not get it served for a month. There's no communication there to tell you, oh, I have a backlog. It's going to take this long. No, you just send it to them and wait. And again, that could take a long time. So in family law specifically, and I want to just kind of put this because I think perspective is important here. Timing can be absolutely crucial to some of my clients. Their safety, in terms of that they could be living with this other party and they need to know when service is going to be coming because they might need to get out. Now, I've talked about this in other episodes. It's very case specific. If you're in a situation like that, I would always say that get out of it. There's things like TPOs, temporary protective orders. I've got another episode about that. If you are, call 911 if it's an actual, like an immediate emergency, and try to get out of those situations, domestic violence shelters, things like that, and get connected with resources. But still, that's the actual reality for some of my clients. Or maybe it's just a toxic environment where it's not that it doesn't rise to the level of a protective order or getting law enforcement involved, but it's just not healthy emotionally for you. Then you need to know, okay, when do I need to leave? And it can be easy to say, well, just leave when you file, but people can't financially do that. And also if you have children together, you can't just take the kids and out of nowhere. And so, timing can be really, really important. If you're co-parenting, for example, and you just ask them for a favor, like, hey, can you swap my days? But you're also filing a modification. Yeah, ask about timing on those kind of things, because I can only imagine it's like, okay, if they go ahead and they get served with the modification action before they were supposed to swap weekends with you, guess what's going to happen? We already know. Never mind, you want to modify things and mess everything up? Okay, well, snatch that weekend or snatch that vacation I said you could go on with the kids. I want you to put it in perspective when you think about how important timing is, because in my job, it is so crucial, and I get that for my clients. The other aspect as a con, I would say, is that they will only serve within that county. So what that means is, like, for example, if you're serving, if you have a divorce, or let's say you have a divorce case, okay, the marital home is in Newton County, right? But let's say that you're trying to get husband served at his apartment that he just moved into in Henry County, right? You can't just get it sent to, now Henry County Sheriff can get it done, but then you're going to have to mail it to them. Like, you can't e-file it and it automatically go to the sheriff's office, because if you e-file something in Newton, which if it was a marital home and everything's in Newton County, more than likely the divorce is going to be filed in Newton County. They're going to send it to Newton County Sheriff. They're not going to send it to Henry County Sheriff. You would have to set that up separately. So again, don't be confused, and I don't want you to take this to say, oh, that means that if the defendant lives in a different county than where I'm filing, the sheriff can't do it. They can. You just have to manually set that up on your own and contact the sheriff's office and probably do a check. And again, think about how slow that takes of then waiting on the mail just for the packet to get to them them put you on the list of, let me put you on the list of the people that I have to go serve. So just things to consider. It's also limited to 3 attempts. So the sheriff's office, again, you have no control over timing. So if you've got somebody with a crazy work schedule, let's say they work nights and they're sleeping all day, so they're never going to answer the door during the day, but then at night they're at work, so they're not going to be there to accept service. Things like that. Those are things that you need to be considering, because the sheriff will go out there 3 times, and I will give them credit that obviously they will try. What I have noticed is that they will try different times of the day in hopes to catch them. But again, you're limited to 3 times, and then, it'll get returned as the service not established or not executed. And so another thing to keep in mind, there's also usually quite a gap between when service is actually executed and you receiving confirmation that it was executed. So like I said, unless you've got that party that calls you right away up and is like, what the heck did you serve me with? Right? Then of course you'll know. And that actually does happen a lot, where my clients are like, yeah, I know they got served because they called me or they texted me, or, which is fine. But as far as actually, if they don't do that and knowing, okay, did they get served? Did they not? Can we get a court date yet? Like a temporary hearing? Can we move things along? Are we still waiting on service? That can take some time, because you're waiting. You're either waiting. There's 2 kind of ways you can find out. You're either waiting on the actual execution of service to be filed into the record, and they will file it, or they'll mail it to you to file. And so it can take some time. So there's really that gap. So overall, although I definitely would say the default method is sheriff's as the process, to go ahead and get done executed by the sheriff, that is not typically the process of service that I choose for my, that fit. I won't say I choose, because my clients do ultimately choose based on my advice and recommendations, but that is not the most popular method in my firm, at least right now. That answer could change just based on the type of cases I might have that year and sort of, what the dynamic looks like. But right now I would not. Right now I would say the number one method is the process server. So process server, what is that? They are not, what a process server, it's not just a random person, because I get that too, where it's like, hey, I can get so-and-so to go hand them the paperwork and take a picture and said it was done. That's great, but that's not going to work, right? That's not a method of service that is actually acknowledged in Georgia by the courts. So an appointed process server, so they have to be appointed. So that means that they are somebody that is certified to serve papers in Georgia. There's a process, You can look it up. I'm not going to necessarily, I'm not trying to teach you how to be a process server in this, but I will say, although I very much value my process servers, they know this. I hope they know this. They are fantastic. They help me so much. And we'll talk about how and why I say that, but they are certified. So this is not just something random. A lot of them are either current law enforcement and they do that on the side. They're retired law enforcement, retired, I don't know. I can imagine like a retired bounty hunter would be great, right? I don't know. But just, they are actually certified. So it's a process that they go through to state that they are certified to be a process server. So let's talk about what the pros in that looks like. The biggest pro is you have way more control over timing. You basically, this is how great, just to give a snippet of what that looks like, how great that timing is. I can ask my client, hey, can you send me a picture of the person we're trying to serve? Okay. I do that. It's not that I actually care what they look like, right? But it's because the process server needs to know what they look like so they know they're serving the right person. And the reason the sheriff's department doesn't really care as much about that is because they're serving them at their home. Whereas my process servers, they sometimes serve them at residences. I've had my process server has served at bars. They have served at gas stations. They have served papers at walking to the grocery store, like literally at bus stops, which is not ideal, but you got to get it done, and people can definitely avoid service and evade service. So you still got to get it done how you got to get it done. And so I say that because you have control over that timing. So you can even say, hey, this is their work schedule. And I can get their work schedule and send it to my process server so they have a good idea. This is basically pinpointing. You're basically saying go at this time or don't go, go at this specific time in this day. And that's huge because, again, it makes sure it gets done and you don't have to think about it. And okay, this day it's happening. Because I have clients that say, hold it for a week. Okay. Or I have clients that's like, let's go, do it now. Literally, I've had a situation where they're like, hey, they're on Facebook Live that they're at this place, they're at this bar. Can you go? And he goes. You get a good process server. That's what I'm talking about. And they go serve because that's someone that if not, I'm telling you, we've waited months to try to serve and just to see where they're at. So anyway, so that's huge. That's the biggest pro about using a process server, the control. And I can even give my process server my client's cell phone number so they can update them on things. So it's fantastic. It removes me as even a middleman. Also, you get almost immediate notice. So like I said, they can have their cell number and say, hey, it's done, got it done. And that helps with peace of mind, if anything, for the client's sake. And like, okay, now I know and I can act accordingly, however that may be. Again, it doesn't necessarily mean danger, but it can mean just attitude, right? Like that's mostly what I see. The other benefit is that there's unlimited, really the sky's the limit in terms of unlimited attempts, right? Like obviously, and we'll get to this, I don't want to jump ahead, but you're paying for those attempts, but still, because it, is their time, but it is still unlimited attempts. So you don't have to worry about, it's going to get sent back to me. No, the process server would happily keep trying. They keep getting paid. So, that's, and we'll talk as we keep going about what happens if it really, like, are we really just going to keep doing this forever? No, there's some alternatives, but we'll get there. Also, and I already touched on this, they can serve at various places. They can do it even, and this is not my favorite way, but sometimes it's necessary, unfortunately, is to do it at custody exchanges, right? Like you might have a legitimation action. I represent the dad. Mom has never shared her home address with you. She doesn't have to. There's no legal obligation. I have an episode about legitimation. If, tune in if you don't know what I'm talking about on that. But mom might have never shared her address with you and you have no way to know it. You're just so distant in that way. So you meet up at a gas station for custody exchanges. You don't know where she works. You don't know any of that. So really, how else are you going to get her served? So it's just something to think about. Again, it's not my favorite by any means, especially, kids are there. But if it's a process server, keep in mind, that doesn't mean they're in deputy clothing. That's another positive that I'm thinking about as we speak more about it, is that it just is like, hey, here you go. I'm serving you with these paperwork. And so it's not necessarily like, oh, you're interacting with law enforcement. Not really. And that can definitely be a pro as well. It's just a person to them. Cons. Okay, so we'll talk about cons because there are cons. The biggest con is the cost. And that's going to differ based on your process server. Their rates are different, just like with anything. But again, it's not super cheap because it is still, you're paying, mileage, plus their hourly rate. And there are situations in which there's stakeouts, right? Like, and what I mean by that is, hey, I have no idea their work schedule, but I know that they live here. Can you kind of stake out until they come outside? Or they're never going to answer the door. So stake out until they leave to go to the mailbox or something. And it's wild, but it's seen it. We have seen it and handled it, and they do that. And so sometimes you have no choice but to do a stakeout if you really want to get service executed, and you have to if you actually want to proceed with whatever you filed. So it's a con because it can be upwards of $100, thousands of dollars, depending on. I've sent paperwork to Brooklyn, New York, to serve someone that was living on the streets. It was like it was a sighting. I knew the block area that they were living, had to get them served, and had to do like a stakeout to see, okay, where is he going to be? And so just an idea that's thousands of dollars in Brooklyn, just if you wanted to know, to get this awesome process server that will serve someone that is homeless. So just some examples. You also usually have to wait for the court to appoint them. I say usually. The counties that I represent, my clients in that I service, yes, that you do have to get them, that specific person, appointed by the court every single time, every case. So even though they're certified, the court still you have to file a motion, ask the court to appoint them as the process server in this case, and then you send the judge, the law clerk, a proposed order granting it, and then wait for that to be signed. Our judges are pretty great. It's a pretty great turnaround on that. It might take a day or two, but still, it is still something to think about. That you're having to wait for. Counties like, and I say my county, it's counties like DeKalb, Fulton. I believe that they've got like a process. I say believe. I really don't go there a lot. I have, but not a lot. It's not my favorite. We could talk about that another time. But still, those are obviously very big, popular counties because they're populated, and so there's a lot of cases going on there. And so they have like a list of process servers that are like already on their list that you don't have to file a motion. So just throwing that out there, but there's no list in the counties that I service. You just pick your process server, and they have to get appointed every single time to the case. So again, a negative, but all of those outweigh the cons. The pros outweigh the cons for process server in a lot of my cases. Let's talk about acknowledgement of service. This is the simplest. Oh, it's the best, right? It's the best, but it's also the rarest. I'll talk to you and you probably can tell why. So this is where you sign an acknowledgement form, literally like just a form, you acknowledge service, and you sign it in the presence of a notary. So the notary, and you're acknowledging receipt of the pleading packet, okay? You are not, and I cannot stress this enough, you are not signing to say that you agree with everything in that packet, right? You might absolutely think it's all lies or all garbage, or you're angry about it, but you're not signing to say cool, yeah, I agree. It's not a settlement agreement. It's not a consent order. You are signing to say, I received it. Just like you would sign for a certified letter or sign for a package, right? You don't know what's in the package, but you signed, well, I got it. And you're signing to say you got it. You don't even know what's in it, right? At least this, you do have received the paperwork. You can look at the paperwork, and you're just signing to say you received it. So it is definitely the simplest. So let's go through the pros. The pros are that the other party does not have to interact with law enforcement. They don't have to interact with a process server. None of that. So there's value in that. It's also the fastest if the other party cooperates, right? And what I've seen in doing this long enough, I have seen where you'll have parties that are like, hey, they told me that they would acknowledge service. So here's their email, send it to them. Or they're going to come by and they're going to acknowledge service. They don't show up. They ignore the emails. They'll say, oh, I'm working on getting a notary and I'll get back to you. That's just buying time. They're not really, a lot of the times, and you're not really going to get it back. So I'll say, okay. So if I send an acknowledgement of service, and the only time I do that is when my client is asking me to, because I'm depending on them to tell me or kind of read the room in that regard and tell me that it's appropriate and we should do that, and that it might work. But when I'm doing that, I'm giving a deadline and saying, if you don't, then I will send it to be served by other means. And what I mean by that is a process server or a sheriff. Just because I've seen that and they just let it drag on and on just to buy time. And maybe they've even looked at what you filed because they go on peach court, right? And they're just like trying to get their own strategy together, buy time for whatever reason. And so in that regards, it's not the best. It's very rare that we do actually get an acknowledgement and turnaround. The times that I have seen it become like it actually happens and we do acknowledgement of service is if they already know it's coming and they've got like counselor ready, right? Like I acknowledge service on behalf of my clients a lot. Like they'll come in for a consultation and they've already been served with something. And, I'll talk to them. Obviously, I would never do that without, them giving me permission to acknowledge service on their behalf. But if they hire me, I'm saying, let's jump right in. Why are we waiting, right? Like why? I know you don't want to have to get served by a sheriff, maybe at your workplace or your house or whatever, and deal with that. Let's just get the ball rolling and I can accept service for you by signing that acknowledgement of service. So let's talk about the cons. I sort of already alluded to most of them, but it's very rare that you have the other party cooperating. Like this is just a very rare thing. It also, because of that, can lead to a delay in making that you think that they'll sign and they won't. There's no cost associated with it, right? Because they're just signing the form and you can file that, and that as long as it was notarized, awesome. But again, and another aspect also I will say as far as a con is that there's times in which I have seen it where someone will, and it's not in my cases, but I've seen it like just sitting in court where they will contest the authenticity of the acknowledgement of service. They'll say, yeah, I never signed that. And again, yeah, it's by a notary. So what happens in that case? Well, we get the notary, we subpoena them, they got to come to court, but it stalls the case, right? So again, process server, I can easily get my process server, to come to court or jump on Zoom hearing and tell the judge, oh, yes, I did. And they've got normally pictures that they take to show the service. So that's what I'm saying about it not being, it's very credible. It's very rarely disputed. And if it is, we're normally going to win against that. I say normally because you never know what comes up, but I don't want to jinx myself. And then same with the sheriff. So again, I would say a con is it could be disputed. I've seen it. It hasn't happened in my cases, but I've seen it. Just kind of sitting in court. The fourth method is publication. So this is, I think this is probably the number one method that people are just not educated on. And they think, okay, I don't know where you're at. I can just put it in the paper and we can get divorced. That is not true. Okay. Service by publication occurs in Georgia when the court grants the motion. So I say counsel's motion because normally it's attorneys that are filing motions, knowing to do that, to serve by publication, which is running it in the newspaper once the motion has been filed. So it's an order. You have to get an order from the court, sort of like with the process server that we talked about. You have to get an order. You ask the court, you file a motion and say, hey, judge, we need, in this case, for XYZ reasons, we need to be able to serve the papers by publication in the newspaper. And the judge then either denies your motion or grants it and writes up an order. You have to have the order to then send to the newspaper to run it. They're not going to run it without that order in the legal section of the newspaper. Okay, let's talk about this. This is, of course, I've already said this is not the default method. This is a very, very last result method. It is, I would say, instead the rarity. The motion that you're filing asking the court to serve by publication has to be very specific. Very frequently, even with attorneys, we'll attempt, right? We'll say, I think I have enough. Not sure if I do have enough for the court to grant this. And it just depends on the judge. And they might deny it and say, keep trying other ways. I'm not going to do this. So the motion has to be very specific as to why publication is necessary in the case. And because of this, you do, if you're dealing with a case in which you're like, okay, I think I might need to serve by publication due to a couple of reasons, and I'll talk to you about that in just a second, some examples, then you need an experienced attorney. You need an attorney that has done, the questions I'd be asking is, well, first off, what do you think? And if you sit down with a consultation, say, what do you think about serving by publication in this case? And obviously, that should prompt a good conversation about why and the specifics of your case and your scenario. But also, specifically that they have experience in getting publication motions granted. and knowing, kind of reading the room and knowing the judge and what steps do you need to go, kind of jump, what hurdles to jump through in order to get that motion granted so that you can keep the case moving. Okay. So I would say recommend an experienced attorney if from the onset, but obviously specifically if you feel like publication is necessary. So let me kind of break down a couple examples when I feel like publication, you cannot just jump and you can probably tell from what I just said, you have to file a motion to show, specify exactly what you've already tried to do as far as service before you can even ask the court for the relief of granting the publication order. So that means you have to exhaust the other methods, and it's not acknowledgement of service. You can't be like, I tried and then they didn't respond, so let's publish it. No, not at all. It means that you have had to pretty much, a lot of times it'll start with, if you started with a sheriff, you have to exhaust that, which is 3 attempts. Then, and it just depends, like the details of the return of service. Does it say that was not, like, an apartment number didn't match up and that didn't even exist there, and so you don't even have a good address? And if that's the case, you're probably at that point going to have to hire a private investigator or do your own research to track down an address. And that's something that I would tell the clients to do before even, jumping in and filing whatever case they're trying to file, because we can't do anything without that information, because we also might need that information. I say might, it depends on the case, to know where to file, because like modifications, they're filed in the county in which the defendant resides. Now, if they don't reside in Georgia, then it could still sometimes be filed in Georgia. It just depends on a couple different things. Again, you would need to consult with a Georgia attorney. But if you're filing something that is like a content action and okay, this is jurisdiction is proper in Georgia, but I don't know where they're at, you really are going to have to get like a private, you can file, but we can't do anything until we actually figure out where they're at. Which again, you can kind of do your own investigation work. Hey, I've been impressed by client skills. My skills aren't bad, but still, I've been impressed by client skills. But also, you're going to have to hire a private investigator in a lot of those cases, especially if they could be anywhere in the nation, depending on what contact you've had with them. And so there's that. There is also just kind of the idea that if you don't do the sheriff, then you at least need then you would jump to the process server, right? So if you've done the sheriff, that has been returned, you haven't executed service, then you get the process server. Even attempts, I'm like, they didn't answer the door. A lot of times that's not going to be enough. What I've seen, I have successfully gotten quite a few publication motions, but I've also been litigating this for 10 years. But I've gotten quite a few publication orders signed and done it that way. But again, that's after I've had my process server write like 2-page paper explaining like exactly everything he's attempted to do and like how he knows that they're like purposely evading service. And he almost like writes it like it's an affidavit that he signs and goes into a lot of detail. And when it has been successful. So again, the pros is it allows a matter to keep moving forward when all other hopes of service would otherwise be lost. Okay, so you're running it. If you get that order, the golden ticket, then you can run it in the paper for 4 weeks and then come to court. And guess what? Service is executed, so you can keep the ball rolling. Does the court actually think that person like happened to look in the paper and see it? No. No. The court pretty much knows 99.9% of the time they did not see that. But again, and it's kind of I guess I would say like archaic of like you're opening the paper, and that is, people did, you would open the paper and that used to be the thing, and look through and see, who's getting married, who had a baby, who's getting sued. But in all honesty, that is, and so the law is like, well, that's just the other method. There's not much of an alternative if you're really thinking about it. And at least it's something. And so that's what we do. But anyway, again, because of that, because the court knows it's not really, it very rarely is actual service, because they're not actually probably reading that and seeing that. It is, you have to really jump through a lot of hoops, and it's the last resort, like very much the last resort. Let's talk about the cons, because the cons is very big for a lot of reasons. So the cons is the timing. You have to let it, not only are you at this point, you've probably already attempted service for like 5-6 months, right? because you've done the sheriff or you've done the process server, and that's even after hiring a private investigator, that sort of thing. So at this point, you're already waiting a long time. But then also you're having to let it run in the paper even once you get the order for 4 consecutive weeks. In the paper, and I want to specify this, not only in the paper in which the county where you filed your petition, but also you have to run it in the county, the state and county, the newspaper in which you believe that they reside, like their last known address. That could be, I've had like big cities, like I've had like in New York. They've lived in the middle. I keep saying like New York, but honestly, or like LA, you have to run it in their local newspaper. That can cost like $1,000+ where, around here, more rural, it's a couple $100 to run it in the paper or less. But, you get to those big cities, those newspaper running things in the legal articles of those papers is a lot of money, and you have to do it in both, and you have to run it for 4 consecutive weeks. So just keep that in mind. So the cost as well as the time. But the biggest thing, it limits the relief that you can seek. And a lot of people don't know that, like in the underlying case. So I'm going to kind of say some more Latin words, because why not? In personam, okay? In personam is basically, you cannot, because in personam jurisdiction is not gained by publishing it. So that means that you never actually got them served with process, like personally. There's no personal service there. It's only by publication. In personam, when you don't have that, there's no financial award. So I want you to think about, which in some cases is fine. That's not the relief you're seeking. A lot of cases, you don't know where they're at, and you're like, I just want to get divorced. I don't want anything from them. We don't have anything together. But I want you to think about child support. You can't get child support with service by publication. Think about alimony cases. Okay, so child support's the biggest one where, you cannot, if you don't get service executed, you can't get child support. And that is huge and a huge form of relief for clients. They need that. They need financial support of their children. And that's how you hear, parents that are just kind of living the gypsy lifestyle because they're evading trying to be put on a child support order, and it's probably working for them. It's sad, but if you if they live that way, but it's the reality that unfortunately some of my clients that are parents have to face. And so it's not, if you hear, well, why don't you put them on child support? I don't know where they're at. Well, so Stephanie said that you can do service by publication. Guess what? It's not helping a lot of clients if there's a financial aspect. Because it's relief that cannot be sought if that's the way that you published, if that's how you executed service. So I want to tell you what service is not. Okay, service is not receiving a lawsuit in the mail. I've had clients that say, I got this in the mail. And I will say there's some attorneys, and I'm not judging style. Okay, it's not my style, but I'm not judging style, that their style is, let me go ahead and just send it in the mail and see what happens. I don't actually think, I'm pretty sure those attorneys don't actually think that means service was perfected. Hopefully they don't. But, that's just their style, and they're like, maybe they'll acknowledge service, or maybe they'll reach out to us and acknowledge service, or, I don't know. I don't do that. But there are attorneys that do that. But that's not service. You have not been served. You could put those papers to the side. And again, I'm not saying I would do that either, but you could put those papers to the side and just sit around, and nothing can happen because there was no attempted service, and that's not service. It's also being emailed documents is not service. So that doesn't mean, I got these documents and the time clock starts. I've got 30 days according to these summons to respond. Absolutely. My advice is going to be seek representation. Like, let's get things started. But I'm the kind of person that's going to say, don't put off what you know is coming, right? But you don't have to. You could put it off because it's not service. It is important to note that the date of service, like when service is perfected, so that's when were you served, because specifically you've got 30 days to respond to the lawsuit, whatever that may be, in Georgia, when the clock starts ticking the day that the service is executed. So not the day that it was filed. You'll see like a stamp file in the top right corner. Not that day, because there could be a huge gap. I don't know. It just depends. Again, we talked about timing with service. It's specifically when you were served is when the 30-day time clock starts. Now, there are some cases in which that time clock is going to be dependent upon when the summons is filed back in, like to say service was executed, because if there is a delay in timing of getting that filed, the statute and sort of a lot of people don't know this part of the statute, even lawyers, but if you delay in filing that summons, then you could push back the clock and give the defendant more time to respond. But that's just something I just wanted to throw in that little fact, fun knowledge sort of thing. It could push back the clock. But for the most part, if the summons was filed timely, pretty quickly after the service was executed, the time clock starts running. Sometimes you might want to buy time to answer, right? Did I say that? I said that out loud. I did. It's just you and I, right? Right here in my office. It's just us. Sometimes you want to buy time to answer, and I'll tell you why. Cost. You go ahead, you meet with counsel, and it's like, I need time to save for that attorney fees for the retainer, and I get it. That's the real world that we're all in. If you're not, you don't get that, awesome, great for you. But most of us are in that situation where it's like, okay, coming up with those funds, I need a little bit of time. And I can say, well, you can buy time because you weren't served yet. When you're served, just know you got 30 days. But and again, there's no default service in Georgia. There's no default judgment in Georgia, which means just because you don't answer in 30 days in a family law case, and that's specific to family law, by the way, then that doesn't mean that there's going to be some judgment against you just because, you're in default. There's no default like in Georgia for family law. But still, you still want to timely file to preserve your rights and to just keep the case moving and make sure that a hearing isn't noticed and, you didn't answer the pleadings and get your viewpoint out there. It is still very important to respond timely. And so again, there can be some strategy involved with service. And if, throughout this podcast, this episode, I have been mentioning that. I've been mentioning a couple tidbits and some strategy because it's true. And it just depends on the goals of your case and your specific case. So overall examples when each type of service might be appropriate. I wanted to kind of make it clear. So sheriffs can be very appropriate if there's no emergency issues and the other party, the defendant, the person you're trying to serve has a very consistent work schedule, or, like when they're home, when they're not home. Okay. It can be great. $50, you don't even have to send anything extra. You can get it. If it's within the county that you're filing, you can just hit click and on the click of a button and it gets to the sheriff's office and it's great and it's done. So those are just some scenarios. Process server. If they don't have a consistent schedule, they need to be served quick or they need to be served quickly so that you can get a court date. So typically you can't get a court date unless service has been perfected for obvious reasons because it's not productive. Like if they haven't been served, that court date would be pointless. Process server, I tell my clients that's normally the option that I would want them to lean towards. Acknowledgement of service would be an option if there's just a lot of cooperation going on and it's very low conflict. Those are kind of the key words that I'm looking for when I'm listening in consultations about what I want to recommend for service options. Publication, again, you've already run through other service methods. You haven't been successful. There's best when there's an affidavit of non-service that is detailing specifically like the due diligence that has been taken to serve the other party and they are just avoiding service. Now, I will say this, you can still simultaneously keep using other methods in order to get that in personam jurisdiction. So if I've got a case where I'm like, okay, my client really does want child support as well, we're not happy about publication, but at the same time, they want to get divorced. So we'll do that route and we'll let it run for 4 weeks, but we're also on the other, that's not barring me from still trying to get them served with process server to get the in personam jurisdiction so we can get the child support award. Okay. Just a little fact. Again, it's going to definitely be dependent upon sitting down with a knowledgeable attorney to really be able to tell you very case specific about which option is probably best for you. Now, don't have your case dismissed by the court for lack of service because that does happen, right? If it's dismissed because it's just been open so long and there's no service, the court will dismiss it. It's not just going to hang out in the docket forever. And the way to avoid this is go ahead and be informed regarding your service options. Contact local experienced counsel that can walk you through these things. As you've been listening, it's not rocket science, I won't say that, but it's definitely not just intuitive. There's a reason that it does require experienced counsel. If you are going through a divorce or you're about to, or you're at risk of disrupting your peace in some way in terms of family law matters, contact me. Contact my office. We can get you set up With a consultation, you and I can discuss a plan for your particular circumstance. Because peace is priceless and attainable. We've got this. Hey guys, I just wanted to jump on and give a disclosure that watching my videos does not create an attorney-client relationship. Also, the information that's contained within the videos is for educational purposes only. Thank you so much for watching.